Judgment in the appeal, the Ministry of Defence and Iraqi Civilians.
Lord Sumption will explain the decision of the court.
This appeal arises out of actions by more than 600 inhabitants of Iraq against the Ministry of Defence. The claims are currently proceeding in the High Court. The claimants allege that they were unlawfully detained or physically maltreated by British troops during the period when the United Kingdom was an occupying or a mandatory power in Iraq. The claims are brought in tort, and it is common ground that liability in tort is governed by the law of the place where the torts are said to have been committed, i.e. Iraq. One of the defences raised by the Ministry of Defence is that the claims are brought out of time and are now statute barred. Under the Foreign Limitation Periods Act 1984, where a claim is brought in England, which is governed by a foreign law, the English court is required to apply the limitation rules that would apply under that foreign law. Iraqi law provides that claims of this kind must be brought within 3 years of the time when the claimant knew of the injury done to them and of the identity of the person who did it. Most of the claims with which this appeal is concerned were begun more than 3 years after the claimant knew of the injury done to them and the identity of the person who did it. The claimants rely on a provision of the Iraqi Civil Code to the effect that the running of time is suspended in certain events. One of them is that some impediment has made it impossible to sue earlier. In that case, the running of time is suspended while the impediment operates. The claimants rely on this provision. They say that there was an impediment which made it impossible for them to sue in Iraq. The impediment consisted in Coalition Provisional Authority Order 17, known as CPA 17, a law introduced in Iraq in the aftermath of the coalition invasion of 2003, which made coalition forces immune from litigation in Iraq. It is still in force. It is common ground that CPA 17 made it impossible for the claimants to sue the Ministry of Defence in Iraq. The Ministry responds that CPA 17 has nothing to do with it because it only applies to litigation against the Ministry in Iraq. It doesn't affect litigation in England, which is the place where they are trying to sue. So the question which arises is this. When the relevant foreign limitation law depends upon some fact, such as the impossibility of suing, does one look at whether that fact existed in the foreign country or in this country where the proceedings are actually brought? The judge ruled in favour of the claimants on this question, and the Court of Appeal in favour of the Ministry of Defence. The Supreme Court unanimously holds that the Court of Appeal was right in the result, although it does so for somewhat different reasons, and dismisses the appeal. Like any other foreign limitation law, the Iraqi law of limitation is designed to apply locally, i.e. to litigation in the courts of Iraq. If the claimants had sued in Iraq, and the Iraqi court would have asked itself whether CPA 17 made it impossible to proceed with the claim in Iraq. The claimants argue that an English court should ask itself exactly the same question, i.e., would the claimants have been prevented by CPA 17 from maintaining the claim in Iraq? If so, then the running of time must be suspended in England. There is an irony about this submission. It would mean that the claims never became time-barred because the Coalition Provisional Authority Order 17 will remain in force as far as one can foresee indefinitely. It means that although the United Kingdom is the only jurisdiction in which the claimants can sue, because they would be entitled to state immunity everywhere else, nonetheless an English court is bound to apply the limitation period of Iraq to facts relevant only to litigation in Iraq, which is not being attempted and never could be attempted. The Supreme Court rejects this argument. The point is a very short one, and in this court's opinion, a straightforward one. The effect of the 1984 Act is that an English court must ascertain what are the relevant rules of limitation in Iraq and must then apply those rules to an action brought in England. If these actions had been brought in the courts of Iraq, an Iraqi court would have had to decide whether there was an impediment preventing the claimants from proceeding in Iraq, but they are being brought in England, and an English court must apply precisely the same rules, but to the facts as they relate to litigation in England. It must therefore ask itself whether there was some impediment preventing the claimants from proceeding with their claim in the courts of England. CPA 17 does not apply to English litigation. It makes no sense for an English court presiding over an action in England to ask itself whether there would have been an impediment to some hypothetical action in Iraq. Accordingly, the appeal will be dismissed.
Thank you. The court is now adjourned.